On February 16, 2014, the New York Times Magazine ran an article by the journalist Mac McClelland called Container City. Container City refers to the Kilis camp in southern Turkey, housing 14,000 refugees from Syria. Protected by high gates and surrounded by barbed wire, Kilis from the outside shares features with many refugee camps all over the world that make them indistinguishable from prisons or criminal detention centers. Kilis houses its population in 2,053 identical containers spread into neat rows. The pictures that accompany the article remind one of shipping containers at a harbor. Each container is a 20 by 10-foot trailer with 3 rooms, a bathroom with its own plumbing and hot water, a kitchen equipped with refrigerator and a stove, and a living room with a color TV with close to 1,000 channels, probably picking up programs from all the surrounding countries of the Mediterranean. Yet there are some unique features of Kilis besides the cleanliness of its streets and the organization of proper electricity, water, and sewage services, which led one Syrian resident to refer to it, quote, as a 5-star hotel. There are schools in the camp, sex segregated according to the wishes of the Syrians, a grocery store where refugees can buy supplies with a credit card of $40 per person for month and $20 for other needs, a beauty salon, a barber shop, artwork, and gymnastics classes. But despite all this, quote, nobody likes living there. It is hard for us, said Bashir Alito, the section leader, who was so effusive in his praise of the camps and the Turks. Quote, inside we are unhappy. In my heart, it is temporary, not permanent. The Kilis refugee camp is among hundreds in dozens of countries of the world. A report by the United Nations High Commissioner of Refugees notes that by mid-2013, the number of worldwide refugees stood at 38.7 million. This was the highest level on record, and with no end in sight to conflicts in places such as Syria, Central African Republic, and the Democratic Republic of the Congo, which you've all referred to, by now, most likely, the refugee population stays at 40 million. As the number of refugees worldwide has increased, not only has the number of camps grown, but the camps have ceased to be places where one held people only temporarily. Rather, the camps have become semi-permanent. The largest refugee camp in the world, Kenya's Dadaab, is 20 years old and houses 420,000 refugees. The Palestinian refugee camps in southern Lebanon are in many cases nearly 70 to 50 years old, depending on whether the refugee population was created in 1948 or 1968. The refugees who live in these camps, and in some cases who have spent their entire lives there, become PRSs, i.e., those in protracted refugee situation. Refugees, asylees, IDPs, internally displaced persons, PRSs, those in protracted refugee situations, stateless persons, are new categories of human beings created by an international state system in turmoil and are subjected to a special kind of precarious existence. Although they share with other suffering strangers, a term that has come up again, the status of victimhood and become the objects of our compassion, as the UNHCR puts it, they become persons of concern, their plight reveals the most fateful distinction between so-called human rights, or le droit de l'homme, as it used to be called, and the rights of the citizen, between the universal claims to human dignity and the specificities of indignity suffered by those who seem to possess only their human rights. From Hannah Arendt's famous discussion of the right to have rights in the origins of totalitarianism, to Giorgio Agamben's Homo Sacer, to Judith Butler's Precarious Lives, and Jacques Rancière's call to the enactment of rights, the asylum seeker, the stateless person, and the refugee have become metaphors as well as symptoms of a much deeper malaise in the politics of late modernity. In this lecture, after briefly recalling Hannah Arendt's discussion of the right to have rights, I will consider Jacques Rancière's trenchant critique of Arendt. Rancière not only misreads Arendt, but much of what he defends as the necessary enactment of rights is quite compatible with an Arendtian understanding of politics. I will then turn to developments in international human rights law since 1948. These developments, I will argue, have not resolved, but only exacerbated conflicts between the territorially demarcated system of state sovereignty and the universality of human rights claims. In the conclusion to my lecture, I return to the quandaries of humanitarian reason in Didier Fassin's felicitous phrase, which a number of you have quoted, while the prevalent mood of cynicism among many, I should say maybe deep disillusionment among many, concerning human rights as well as humanitarianism is understandable, it is not defensible. We need a new conceptualization of the relationship between international law and emancipatory politics, a new way of understanding how to negotiate the facticity and the validity of the law in Habermas's terms, including international human rights and humanitarian law, such as to create new vistas for the political. Let me begin with Hannah Arendt. In a well-known and much discussed passage in The Origins of Totalitarianism, Hannah Arendt wrote, quote, "We become aware of the existence of a right to have rights, and that means to live in a framework where one is judged by one's actions and opinions, and a right to belong to some kind of organized community only when millions of people emerge who had lost and could not regain these rights because of the new global political situation." She goes on, "The right that corresponds to this loss and that was never even mentioned among the human rights cannot be expressed in the categories of the 18th century because they presume that rights spring immediately from the nature of man. The right to have rights, or the right of every individual to belong to humanity, should be guaranteed by humanity itself. It's by no means certain whether this is possible," she concludes. The right to have rights, therefore, has become the well-known phrase through which to capture the plight of the stateless, the refugee, the asylee, and the displaced person. That is, the plight of those who have been cast out of the framework where one is judged by one's actions and opinions. I want to single out, very briefly, several sets of philosophical issues which run through these famous passages. First, the normative justification of rights, and in particular, of the right to have rights. I guess this would put me in the deontological camp from what I gather from this discussion that's been going on here in the conference. Throughout this discussion, Arendt polemicizes against the grounding of human rights upon any conception of human nature or history. For her, conceptions of human nature commit the mistake of treating humans as mere substance, as if they were things in nature. But following Augustine and Heidegger, for her, humans are the ones for whom the question of being has become a question. She quotes Augustine, "Quid ergo sum Deus meus, qua natura sum?" What then am I God? What is my nature? The answer simply is, quaestio mihi factus sum, I have become a question to myself. And this capacity for self-questioning is also the source of one's freedom. Although human freedom is not limitless and is subject to the facticity of the human condition, in her words, worldliness, plurality, natality, and labor, work, and action, it is with reference to this human condition alone, and not in the light of a fixed concept of human nature, that we must try to justify the right to have rights. Now, Arendt's rejection of any justificatory role that the concept of history may play is complex. We know that since the late 1950s, she's engaged in a conversation with Karl Marx, whom she accuses of having brought the tradition of Western political philosophy to an end by substituting a philosophy of history for a political philosophy proper. Arendt's reading of Marx is often dismissive, and I'm not concerned to evaluate it here. But for her, as for Walter Benjamin, whose thesis on the philosophy of history, the famous thesis on the philosophy of history, she brought over to the United States with her in a suitcase after his suicide in Portbou, Spain, and from whom she learned a great deal. Any deterministic account of history, either privileging a mechanism of social forces that act as the engines of change, or any teleological account of history which attributes to it an end goal, is intellectually shallow. Even more, it is morally reprehensible because it makes human beings into an instrument of world spirit and robs them of oppositional agency. One has to act against the grain of history and be utopian sometimes, to use a Benjaminian locution. Now, I am going to skip the philosophical discussion of justification. There's lots here about whether Arendt is a political decisionist or existentialist, more in the tradition of, Carl Schmitt, etc. But I just want to quote one passage from Hannah Arendt, which is, I think, crucial for understanding her politics of human rights. She writes, "Our political life rests on the assumption that we can produce equality through organization because man can act and change and build a common world together with his equals and only equals. We are not born equal. We become equal as members of a group on the strength of our decision to guarantee ourselves mutually equal rights." Let me leave this passage uncommented on. I can return to it if you wish. I have written one book on Arendt, and I'm about to publish another collection of essays, so I will just leave that as it is now. And let me turn to Jacques Rancière. In Who is the Subject of the Rights of Man?, Jacques Rancière subjects Arendt's discussion in these famous passages to a trenchant critique. Composed in 2004, after the US invasion of Iraq had taken place and the wars in Afghanistan and Iraq were at their height, Rancière begins by noting that the rights of man, or in more contemporary languages, we would say human rights, which were rejuvenated by the dissident movements of Eastern Europe and in the Soviet Union in the 1970s and 80s, were transformed in the first decade of the 20th century into something strange. He writes, "The rights of man have been transformed," I'm quoting, "into the rights of the rightless, of the populations hunted out of their homes and land and threatened by ethnic slaughter. They appeared more and more as the rights of the victims, the rights of those who were unable to enact any rights or even any claims in their name, so that eventually their rights had to be upheld by others at the cost of shattering the edifice of international rights in the name, and note this, of a new right of humanitarian interference, which ultimately boiled down to the right of invasion." Human rights then, according to Rancière, the rights of the rightless, become the ideological scaffolding for interventionist reason, at best, R2P, and for varieties of military intervention at first. Now, Rancière's essay is rich in polemic and sweeping in its generalizations. Often it is hard to distinguish between what Arendt said and the way Arendt's words have been deployed by others such as Giorgio Agamben. Let me just say two sentences here. Commenting on Agamben's claim that, quote, "the camp can be put as the nomos of modernity," end of quote, Rancière notes that refugee camps, the zones where illegal immigrants are parked, such as Melua in Spain or Lampedusa, Italy, or historically the Nazi death camps, all can be subsumed under the sweeping logic of sovereignty exercising biopower. This is indeed the night in which all cows are black, to use a Hegelian locution, and this is a mode of thinking for which all relevant distinctions disappear. Unlike Arendt, who separates carefully the unique logic of totalitarianism from that of modern mass democracies and many other regime forms such as tyranny and despotism, the camps appear here as the culmination of a logic of biopower intrinsic to modernity. This is Giorgio Agamben, perhaps Zygmunt Bauman, and upon a careless and contentious reading, maybe even the dialectic of enlightenment of Adorno and Horkheimer. But it is not Hannah Arendt. Rancière at times differentiates between what Arendt and Agamben say. At other times, he seems to suggest that Agamben's misreading of Arendt, and indeed it's a deep misreading, is justified on the basis of her own confusions. But Rancière's main disagreement with Arendt centers around the question of democracy. Arendt, on Rancière's reading, cannot see that the essence of democracy is challenging the boundary between the private and the public. Instead, he claims she essentializes the public-private distinction. And in a critical sleight of hand, according to him, the stateless, the refugee, and the asylee are supposedly identified by Arendt with the private, poor, unpoliticized individual. Yet, Arendt's point is precisely that the poor, the unpoliticized individuals, if they are unpoliticized, belong to a polity. They are members of some human community, and their condition cannot be compared to that of the stateless, whose plight is that no human community seems to want them. Recall here her ironical comment that even prisoners had more rights than the stateless. Why is Rancière so obviously misreading Arendt? Primarily because he wants to fit Arendt's position into his position of what he calls the scheme, primarily because he wants to fit Arendt's position into his scheme of the archi-political, which he understands as a false depoliticization of matters of power and repression and setting them in a sphere of exceptionality that is no longer political, in an anthropological sphere of sacrality situated beyond the reach of political dissensus, end of quote. This then unfolds into a critique of Arendt's distinction between the private and the public realms, and ultimately her separation of the technological and economic matters from political ones. Now, Arendt's admittedly faulty views, particularly on the question of the economic, which she treats as if it were a technological issue, have nothing to do with either a sphere of sacrality or with that of a state of exception. And I dare say that many of us who believe in the art of careful reading, such as Richard Bernstein, Hannah Pitkin, and myself, have subjected Arendt's thought here to a critique. But leave the question of democracy for the moment aside. What has become, in Rancière's analysis, of Arendt's reflections on the modern state system of sovereignty, which for her, after all, creates the refugees, the stateless, and the asylum seekers? What of her concerns for the legal and political condition of the stateless and the refugee? What about the right to have rights? How can the right to belong to some political community be guaranteed by humanity itself when, as she admits, this may not be possible? Rancière focuses on the problem of democracy, and very insightfully so, but then he completely leaves aside the transnational dimension of the constitution of the boundaries of democracy, who belongs to the demos, which is where Arendt's questions are to be situated. There's one discussion of Rancière's here about his paradoxical formula, which I'm going to go over very briefly, where he says the rights of men are the rights of those who have not the rights that they have and have the rights that they have not. Okay? The rights of men are the rights of those who have not the rights that they have and have the rights that they have not. I'm going to interpret this as a kind of conflict between human rights and the rights of the citizen, and see what we can do with their antagonism, agonism, and décalage. Since Hannah Arendt penned her discussions of the right to have rights, international institutions and international law have changed the landscape against the background of which she wrote The Right to Have Rights. The book was published in 1951. Thus, as many of you here know, the UDHR in Articles 13, 14, and 15 addresses some of the germane questions that she reads. Article 13, as you know, guarantees the right to immigration, but not immigration. There is no international human right to enter a country, although there is an international human right to leave a country. And some of us have worked philosophically on whether or not the asymmetry here in Article 13 is meaningful. This may be one way in which we can, contribute to something. Article 14 encodes the right to asylum. I'm not going to read it. I'm assuming you all know it. Article 15 seeks guarantees against denaturalization or loss of citizenship. Together with the United Nations Convention on the Prevention and Punishment of the Crime of Genocide of 1948, maybe the first formulation of some version of R2P, the 1951 Geneva Convention on the Status of Refugees, and in particular the two international human rights covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, these documents and the institutions of compliance and monitoring have altered the legal landscape for the entitlement to and exercise, or in Rancière's terms, the enactment of human rights. Just to remind you, and you will see that I think there is a constructive discussion between myself and Aiden here, which will become clearer as we get into the function of norms. But the International Covenant on Civil and Political Rights, which was open to signature in 1966 and entered into force in 1976, has 167 out of 195 state parties to it as of 2013. We may interpret that as we wish, but that is a whopping number that we have to, take into account. Likewise, the International Covenant on Economic and Social Rights has 169 state parties out of 195. And the last time I looked, CEDAW, the Convention Against the Elimination of Discrimination Against Women, had about 185 signatures out of 195. There is an intense contemporary debate, not only among social scientists, but also among political philosophers and legal theorists, about how to characterize these changes in the international legal regime. Should we characterize them as leading to a regime of legal cosmopolitanism to core, or do these changes amount to a transformation in regimes of state sovereignty which give rise to something like a dualistic international order of global governance on the one hand and the continuing state system on the other? I have defended a position of moral and legal cosmopolitanism in works such as The Rights of Others, 2004, Another Cosmopolitanism, and Dignity in Adversity, which I define as the proposition that we ought to consider each human being, qua human being, as a person entitled to basic human rights and not because they are a national or a citizen of a state. This is not a descriptive claim about the way the international state system functions. It is rather a regulative ideal in the Kantian sense of the term. A regulative ideal is an ought statement addressed to agents who, through their actions, can bring about the state of affairs that the regulative statement only points to. The issue is whether legal cosmopolitanism can become not just a regulative, but also a constitutive ideal of the international community as well. Now, there are some institutional trends, contradictory and weak ones, that try to mediate the gap between these regulative and constitutive dimensions of international human rights. The distinctive feature of many human rights covenants, this is uncontroversial, of the post-war period is that while states and other state parties are signatories to these covenants, in doing so, they undertake to bind their own legislation, policies, and regulations in some sense in accordance with these international obligations. This means that states remain the principal actors for the guarantee and respect of human rights, as well as being the political domain within which human rights are enacted and interpreted. And of course, if you're familiar with international law, you know that states also impose RUDs, reservations, understandings, and derogations, which give them the escape hatch not to be compliant with certain clauses. But this again creates a very interesting area of analysis because it changes. Sometimes they put a RUD on one item and they come back 6 or 7 years later, they modify it. This is not a one-time take it all or leave it process. It's an ongoing process. But as multilateral global governance institutions such as the WTO, WHO, NATO proliferate, increasingly compliance with international human rights norms in general is also expected of these institutions. They have obligations, quote, to respect, protect, and fulfill human rights according to the Maastricht guidelines on violations of economic, social, and cultural rights, which were formulated or convened on the 10th anniversary of the implementation of the ICCPR. However, the fact that states remain the principal domain within which human rights are enacted and interpreted does not mean that they are the only domain of the political or the public sphere of our times. In fact, what has emerged is an international as well as transnational politics of human rights, which is different than humanitarianism, traveling across state borders, but often deeply impacting human rights struggles within the states themselves. This is a development which Arendt could not foresee. Now, let me try to elaborate on this a bit more. With the advent of international human rights law, individuals are recognized as holding human rights directly under international law. Again, this is a revolution. If one compares the discussions among international lawyers in 1948, who thought that this was an absolute chimera, the idea that this is, what we've moved to today. I mean, people like Kelsen, right? Who were the first global constitutionalists, were working for this, but thought that we needed a universal court as well. We don't have a universal court, but we do have a strange system that is emerging. But what does that mean concretely, again? It means, in the first place, that the civil and the political rights of citizens, as codified in various constitutions and bills of rights, can themselves be criticized in light of internationally acknowledged human rights standards. There is a dialectic between international human rights and civil rights. Particularly, the transnational women's movements across the globe have used CEDAW to force their governments and public institutions to comply with the Convention standards for equal pay for equal work, against sexual harassment, sexual discrimination, and for consideration of women's special health and physical needs. Other examples can be drawn from social struggles and litigations made possible by the Covenant on Economic, Social, and Cultural Rights in enabling indigenous group struggles for their own territories and cultural patrimony in the global South. As you know, an intense debate is now raging in the United Kingdom since the UK acceded to the European Convention for Human Rights and Fundamental Freedoms about prisoners' disenfranchisement or loss of voting rights, which was recently ruled against by the European Court of Human Rights. In all these instances, and this is my point, international human rights instruments have created a conceptual and normative space within which what I call a jurisgenerative struggle is taking place. By jurisgenerativity, I mean the following. This was a term that was first used by the legal philosopher Robert Cover, then picked up by Frank Michelman, and I'm continuing and elaborating on it, and there are some shifts here, but that is not the issue. By jurisgenerativity, I mean the following. Laws acquire meaning in that they are interpreted within the context of certain rules and significations which often cannot be controlled. There can be no rules without interpretation. Rules can only be followed insofar as they are interpreted, but there are also no rules, including legal norms, which can control the varieties of interpretation each rule can be subject to within all different hermeneutical contexts. In that sense, norm interpretation is always an open hermeneutical challenge. Law's normativity does not consist in the ground of its formal validity, i.e., its legality alone. Law can also structure an extra-legal normative universe by developing new vocabularies for public claim-making, by encouraging new forms of subjectivity to engage within the public sphere, and by interjecting existing relations of power with forms of justice to come, à venir in Jacques Derrida's terms. That is to say, jurisgenerativity looks also at the space of normativity that is created by the law, in that it creates new vocabularies for public claim-making, permits new subjectivities to enter into the public sphere that may or may not have been intended by the law, and has these anticipations of justice which the law can never fully fulfill. In that sense, law is not simply a method of coercion and an instrument of domination or the silencing of dissensus, as Jacques Rancière claims. Undoubtedly, law is also a medium of coercion. But the disjunction between the facticity and validity of the law, Facticität und Geltung, is the space into which a politics of jurisgenerativity can be inserted, which both signals to the presence of this gap between facticity and validity and tries to bridge it in the name of future forms of justice to come, thus once more bridging the regulative and constitutive ideals in Kantian sense. Let me return then once more to the right to have rights in view of these considerations. International human rights law since 1948 has created norms, instruments, and institutions through which the contention between states' treatment of non-nationals, documented and undocumented migrants, refugees, asylum seekers, displaced persons, and stateless and their human rights can be framed and litigated. It is in this domain, however, that sovereign privilege still retains its most brutal form, and we see the ironies of humanitarian reason at work. Didier Fessin, to whom we owe this term, and whom many of you have invoked, defines it as follows, quote, "Humanitarian reason governs precarious lives, the lives of the unemployed and the asylum seeker, the lives of sick immigrants and people with AIDS, the lives of disaster victims and victims of conflict, threatened and forgotten lives that humanitarian government brings into existence by protecting and revealing them." And you will know the critique of humanitarian reason is called a moral history of the present, maybe connecting back to some of the discussions you were having early this morning. Yet, as Didier Fassin also notes, sometimes there are legal victories that oblige recipient states to grant undocumented or illegal migrants with AIDS the rights to stay, who would most likely perish if they were rendered back to their countries of origin. At other times, as is happening quite often in the United States, even a parent of an American child who remains without parental supervision is deported because he or she does not have the proper documentation. Sometimes the application of a refugee for asylum is denied after 10 years. In the meantime, this person has married and has integrated into civil society of the country in which she is illegally in residence. In some cases, she is summarily deported to a country of origin and a life which she has never known. In other cases, as in the Netherlands, for example, humanitarian reason is exercised through a process of dulden, I think, roughly tolerance, such as to enable those undocumented migrants to disappear into the folds of civil society and live below the radar of legality. This changed landscape of international humanitarian and human rights norms, I want to suggest, is among the many factors that is giving life and legitimacy to movements such as those of Les Sans-Papiers in France, the Dreamers in the United States, and the Los Indignados in Spain, many of whom themselves are documented and undocumented migrant workers. These individuals are demanding very often the rights that they do not have, at least according to the state's constitutions in which they may be residing. If Rancière had a less truncated understanding of the law, he would see that the politics of jurisgenerativity is one of the prime instantiations of the politics of demanding the enactment of rights. Let me move slowly to a conclusion. As political fatigue about internationalism has gripped the US in the wake of the interventions in Afghanistan and Iraq, and President Obama's politics of caution and contradictions in Syria have further created moral quagmires, we have moved from the right to have rights to the critique of humanitarian reason. Didier Fassin, who for many years worked with Médecins Sans Frontières in a high capacity, is brutally honest about the shortcomings of humanitarian reason, which is certainly one of the offshoots of the politics of international human rights, though certainly not the only politics possible. He writes again, "I have tried to grasp what humanitarian reason means and what it hides, to take it neither as the best of all possible governments, nor as an illusion that misleads us. It seems to me that by viewing it from various angles, we can render the global logic of humanitarian reason more intelligible." End of quote. As I read Fassin, he's an ameliorist. He's a dedicated liberal reformer. Some of you have referred to the book. Maybe we have different understandings of what that book is about. But I see that book as, being an, sober and dedication to continuing the project of liberal internationalism and humanitarian reform. But if you wish, we can discuss that. This cautious assessment is to be contrasted with the words of Samuel Moyn, whose much acclaimed book, The Last Utopia, Human Rights in History, best illustrates the jaundiced sense about human rights that has gripped the progressive community. Some sought to achieve, Moyn writes, quote, through a moral critique of politics, the sense of pure cause that had once been sought in politics itself. Furthermore, according to him, human rights substituted a plausible morality for a failed politics. And using a more cutting formula, he asserts that human rights were born in anti-politics and that they survived a moral utopia when political utopias died. And in Moyn's, some passages of his reconstruction are very exciting, but basically what we are being told is that the politics of human rights is a substitute for the failed energies of Marxist revolutions. This is the gist of it. These are not only provocative claims, but also fighting words based on binarisms that have never been clarified. Morality is juxtaposed simply to politics, utopianism to realism, and liberal internationalism to a dreamy, fuzzy cosmopolitanism, both of which are said to be antagonistic to democratic sovereignty. Ironically, Hannah Arendt, the most trenchant critique of national sovereigntist delusions, is summoned by Moyn to his side with the claim that the history of human rights, quote, reveals the persistence of the nation state as the aspirational form of humanity, end of quote. Moyn's work, I think, is part of an amoral turn in our understanding of the political, one that blends together good old-fashioned nation-state-centered political realism, whether Marxist or not, with a postmodern skepticism towards normativity. I've tried to argue in this lecture that the sea change from the right to have rights to the critique of humanitarian reason, however, should neither lead us to the defense tout court of the sovereigntist nation-state system, which obviously is in trouble, nor should it produce a flippant dismissal of the realm of law and international institutions as being products of a repressive imaginary of consensus. Rather, one has to recognize the unending tension and disjunction between facticity and the validity of law and of institutions in general as they give rise to those cracks and fissures into which a politics of jurisgenerativity can intervene, and where indeed we can call for radical legal reform. Why not? Thank you.